We're here with Tim Davies, a lawyer and specialist in continuing healthcare funding. First of all, Tim, should my relative have to pay for care costs?
Well, not necessarily. The base position in the absence of any funding from the NHS is one of a means testing position. So what they look at is whether the individual has assets exceeding £23,250. If they do, then in effect they're expected to pay for the full cost of their care until their money goes below that figure, and that can include any property they own. Now, even once they go below £23,250, they continue to have to contribute until their assets fall to a lower level of £14,000. Even once there, unfortunately, they could then continue to have to contribute to their care costs from any income they receive, so for example any pension. And they're left with a very small token gesture, which is referred to as sort of pocket money really, while the local authority will then make up the difference to the agreed level that the cap that they will pay per week. Now, that is all utterly irrelevant if it can be established that the individual's need for care is primarily a health need. In those circumstances, the NHS are obligated to step in and they will pay the full cost of the individual's care, whatever that may be, wherever that is, and that's known as continuing healthcare funding. So it's not in any way means tested. The individual can quite literally have £1 million in the bank, as a rather extreme example. If their needs are health needs, then they should not have to pay.
Whereabouts where are you based in the country? If I'm in a different part of the country, how do I get in touch?
Well, we act nationally for a start, so we cover across England and Wales. Unfortunately, Scotland have different rules and regulations, as do Northern Ireland, so we can only assist in England and Wales, but we do act nationally. We have offices in Birmingham, as well as in the southwest, and we have an office in London as well, so we're able to cover from those bases absolutely everywhere within England and Wales. We don't charge for our travel time, so if, for example, it's necessary to attend a meeting or an appeal hearing, you're not penalised financially for our having to attend because we're further away from you in the country. That's a deliberate decision we've made to be more competitive than other solicitors who traditionally charge an hourly rate for their travel time as well. We want to ensure that you're instructing an expert in the area rather than going to someone who purports to be able to assist who's local to you simply to act as a cost saving. We're very keen to ensure that you receive the best service and that geographical location should not be a bar to that. So in essence, the first stage in the process is simply contact us and we can go through matters with you, as I mentioned before, in confidence and with no obligation, and there's no cost to that either.
And I've heard of the term power of attorney. I don't really know what that means. So what is a power of attorney?
A power of attorney in its very basic format is a document that grants the authority to another individual to act on their behalf in respect of both property and financial affairs and separately health and welfare. The individual themselves has to have granted that authority whilst they retained the mental capacity to be able to do so. So they have made a conscious decision to say, in the event that I unfortunately lose my mental capacity, I would like this individual, this nominated attorney, to make decisions on my behalf, and I trust them to do so. So it's a formal legal document that has to have been registered with the Court of Protection, and there is a cost for doing so and a cost for setting that up. Now, the relevance of that to the continuing healthcare funding process is that it's very important to be able to have somebody acting on your behalf without there being any dispute. In the absence of a power of attorney, the NHS still have to deal with the family or the representative, but it can be somewhat more complex a process, and there have been certainly disputes that we've encountered in the past where the NHS have been quite obstructive in the absence of an official power of attorney. Now, the national framework for continuing healthcare funding, as I mentioned before, the rules and regulations that govern the process, makes it very clear that the individual's representative or family member should be fully included in an open and transparent process at every stage. Now, it makes no mention or requirement that that individual has to have the power of attorney, perhaps in anticipation of the fact that very often these documents are not something that's been organised prior to somebody health deterioration to a state where they need this process to be conducted. So again, the key point is that it's a matter of having an expert in your corner to be able to make these arguments for you in the situation where you encounter any resistance or difficulties. What I would say is that if you are looking down the barrel of there being potential issues in the future regarding a relative having to go into care, if they retain their mental capacity, then it's very important that they put these measures in place to be able to assist the family in the worst case scenario that they lose their mental capacity. So I would always suggest that the family, obviously subject to the consent of the individual, arrange for powers of attorney to be put in place. Equally, it's important that both parts of the power of attorney for property and financial affairs as well as health and welfare are secured, because again we've encountered instances where the NHS have been somewhat difficult about dealing with a family member or their representative where they only hold the power of attorney for property and financial affairs and not health and welfare. There can be problems in securing the release of medical records, there can be problems in even engaging with the NHS to ask them to conduct what they say is a health and welfare matter in the absence of that document. Now clearly that's somewhat of a flawed thinking, because what we're looking at here is whether somebody should be paying for their care, if they should be paying or if they shouldn't. Now, how that can fall under anything other than a property and financial affairs issue is clearly open to debate. I think it can only be a point of consideration and of relevance to that particular area. So again, don't despair if you do not have a power of attorney, or if you only have a power of attorney for property and financial affairs. It makes no odds. Still, don't think you can't take this process forward. You still can, but the point is that you need an expert in our corner, and it's something you should call us to discuss. On a final point, there was a change in the law regarding powers of attorney, where previously matters were dealt with by what was known as an enduring power of attorney, and those have been replaced by lasting powers of attorney for property and financial affairs and for health and welfare. Now, that does not mean that if you only have a enduring power of attorney, that document is no longer valid. It is. It's still a legal document, and it's still equally as pertinent to the process as it was before. All that it means now is that you can no longer secure enduring powers of attorney, but if one was put into place before the change in the regulations, it's still a valid document. Again, as with all of this, it helps to have expert advice in your corner, so just contact us and we can answer and address any queries you have in any area relating to care costs and the surrounding problems. Perfect.
That do?
Yeah, I think so. I can't think.